Hi everyone, my name is Beth Brown and I am counsel in the Pensions Group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. And welcome to this episode. In this episode, I will summarise the Pensions Regulator's interim regime in respect of defined benefit superfunds. The term superfund is used by different people in different ways, so I will start off with a short explanation of what a superfund is. A superfund is a defined benefit, or DB, pension consolidation vehicle that brings together several different pension schemes into one single fund. Superfunds are designed for schemes that have no real prospect of achieving buyout, and they allow the seeding trustees and the scheme sponsoring employer to discharge themselves from their liability towards the scheme and its members. The key advantages of superfunds is the cost efficiencies linked to the economies of scale and the pooling of risk. However, as superfunds are a relatively new concept, as of yet there has been no formal legal framework put in place for their regulation, and no pension scheme has made that leap into a superfund. The Pensions Regulator, which I will refer to as the regulator, ran a consultation back in 2019 and has now issued guidance and an interim framework following that consultation. There are three separate guidance documents for superfunds themselves and for seeding employer and trustees, i.e. those contemplating using a superfund. The guidance precedes the introduction of a formal legal framework for superfunds, and whilst it's not legally binding, the regulator has stated that it intends to regulate superfunds to ensure that members' benefits are protected. The regulator also recognises that this is an evolving area and will therefore continue to develop its guidance on DB superfunds. We do not yet have any expected timeline for the introduction of the legislation required to enshrine the framework into law. The key messages from the guidance are: first, superfunds will be expected to submit themselves to detailed initial assessment and ongoing supervision by the regulator. The guidance sets out the regulator's expectations as to funding, including specific assumptions for minimum technical provisions, investment, transfers in, and the capital buffer. The guidance also covers matters such as governance, fitness, and propriety of key personnel and financial sustainability. Secondly, seeding employers will be expected to apply for clearance since the regulator views a transfer to a superfund as a Type A event. And thirdly, seeding trustees will need to be satisfied that a transfer to a superfund is in the member's best interest. The guidance lists issues and advice which the trustee will need to consider for this purpose. Trustees should be ready to share their conclusions with the regulator. In the regulator's view, a transfer to a superfund is unlikely to be in the member's best interest where there would otherwise be a reasonable prospect of a buyout in the foreseeable future, which is generally taken to mean the next 5 years. I will now cover the key features of the interim framework in a bit more detail. Starting with the initial assessment and ongoing supervision, it is worth noting that A. New superfunds will need to submit extensive information to the regulator prior to their launch to demonstrate that they satisfy the regulator's expectations and that adequate governance procedures are in place. And B. Those running the superfund will be expected to engage with the regulator in an open, honest, and transparent manner on an ongoing basis. The initial framework also, as you would expect, focuses on funding. Due to their scale and the large number of members that will be relying on them, The regulator is very keen to ensure that superfunds are properly funded. As such, the regulator has stated that funding requirements must apply on a transfer into a superfund. Prudent assumptions should be used when technical provisions are set. Superfunds must have a legally enforceable low-risk funding trigger which would apply when the scheme assets and the capital buffer are lower than 100% of the minimum technical provisions level. At this point, in the absence of a fresh capital injection, all of the funds in the capital buffer would come under the control of the trustees, and there must be a legally enforceable winding up trigger set at 105% of the PPF funding level in order to provide protection against a claim being made on the PPF. If funding were to fall to this level, then the superfund would automatically be wound up. Moving on to the capital buffer. This is the term that is used to describe capital that is invested into a superfund, either by external investors or by seeding employers. For superfunds, the capital buffer replaces the employer covenant. It is not an asset of the fund, but it does form part of its longer-term security, and it is therefore very important that it is safeguarded appropriately. The guidance states that the buffer should cover asset and liability risks specific to each superfund. For example, if a particular superfund has a high-risk investment strategy, then a higher capital buffer would be required to cover that risk. As I mentioned earlier, the regulator considers a transfer to a superfund to be a clearance type A event and therefore expects a clearance application to be made. It also notes that no transfers to a superfund should be made if there is a potential for the transferring scheme to achieve a buyout within the next 5 years. Seeding employers will need to explain to the regulator why there is no realistic prospect of a buyout occurring, as well as evidence that transferring to a particular superfund is the best option for members of the scheme. Another point I would make is that the regulator expects trustees to engage with it at least 3 months before any planned transfer to a superfund. Another key point is that the regulator expects that no surplus value should be extracted from a superfund, including the capital buffer, unless members' benefits are bought out in full. This is to ensure that those running superfunds have interests that are aligned with the members and reduce the likelihood of excessive risk-taking. Related to minimising risk, the regulator expects that financial reserves of the company running the superfund must be ring-fenced, and there should be a robust business plan in place which is shared, along with the financial information, with the regulator. The key individuals running the superfund must be fit and proper persons. The superfund's capital buffer and pension scheme will comply with the regulator's investment principles for superfunds. And finally, there should be a robust integrated risk management framework in place. Overall, the interim regime and guidance recognises that there is a demand for DB consolidation, but the protection of the members' benefits and the need to have a well-run scheme, whether a superfund or not, remains paramount. It is likely that the regulator will be taking a very hands-on approach to superfunds, and it has acknowledged that this is an evolving area. Indeed, we expect that the trustee and employer guidance on superfunds will be updated in the near future. Please feel free to email me with any comments or questions on this episode to bbrown@mayorbrown.com. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances. Finally, before you push stop, just a quick reminder that the time spent listening to these episodes can count towards the solicitor's continuing competence and PMI CPD requirements. All the episodes are available on our Mayor Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Thank you for listening.